Okay, so get this. You're a government authority, right? And you set up this special zone to attract all this foreign investment,
Mm-hmm.
only to find yourself in the middle of a bankruptcy battle, and millions of dollars are on the line.
Yeah.
That's what happened in this case, straight from India's Supreme Court. And today, we're
Wow.
going to do a deep dive into how it all went down.
Sounds fascinating.
Me.
I'm excited to break this one down. It's a really interesting case that highlights just how complicated India's insolvency and bankruptcy laws can be.
Yeah.
We're talking about the Noida Special Economic Zone Authority, or NSEZ, which is basically like a designated area with special economic regulations
Right.
designed specifically to attract foreign companies.
Yeah, it's like a VIP zone for businesses.
Exactly. Think tax breaks, streamlined processes, the whole 9 yards.
Yeah, exactly. But in this case, the VIP treatment didn't quite work out for NSEZ.
Yeah.
They ended up on the losing end of a dispute with a company that had been defaulting on rent for years.
Yeah, for years.
Yeah.
Let's break it down. So this company, Sri Bhumika International Limited,
Okay.
they leased land from the NSEZ in this special economic zone. But here's where it gets interesting.
Okay.
The NSEZ itself was actually leasing the land from another authority, the Noida Authority.
Yeah.
So it was kind of a subleasing situation gone wrong.
Oh, wow. So the NSEZ was playing landlord, but they didn't even own the land outright.
Exactly.
Talk about a recipe for disaster.
No?
So what happened? Did the company just stop paying a rent and get away with it?
Well, not exactly.
Yeah.
They started defaulting on their lease payments way back in 1999
Oh, wow.
and had been pretty much inactive on the land since about 2003, 2004. There was even an attempt to sell off the company's assets in 2018
Okay.
for a decent sum, about INR 9.18 crores, but the deal fell through.
So we've got years of unpaid rent, a failed asset sale. This is already sounding like a legal nightmare.
Oh, yeah?
What did the NSEZ do?
So finally, in 2019, they decided enough was enough.
Right.
And initiated something called the Corporate Insolvency Resolution Process, or CIRP.
Yeah.
This is basically a formal process for dealing with a company that can't pay its debts.
Yeah.
So this led to the appointment of an interim resolution professional,
Okay.
someone who basically steps in to manage the company's affairs during this process.
Right.
And then they formed a committee of creditors.
So that's where the big players come in, the ones who are owed money.
Exactly.
Oh.
And in this case, the committee of creditors consisted only of the Stressed Assets Stabilization Fund, IDBI Bank Limited,
Okay.
a pretty powerful player in the Indian financial world.
Yeah.
Of course, the NSED filed a claim for the money owed to them,
Right.
which was over INR 6.29 crores, a huge amount. And their claim was fully admitted by the appointed resolution professional.
So far, so good, right? Seems like they were finally getting somewhere.
Well, that's where things take a bit of a turn.
Okay.
You see, this whole process is about figuring out how to resolve the company's debts,
Uh-huh.
which could involve selling off assets, restructuring the business,
Yeah.
or even liquidating the company entirely.
Yeah.
To do that, they need to figure out how much the company's assets are actually worth.
Okay. Let me guess. The valuation came in much lower than what the NSEZ was hoping for.
You got it. 2 independent valuers were brought in,
Okay.
and they determined the liquidation value of the assets to be just INR 4.25 crores, significantly less than NSEZ's claim.
Wow.
And get this, the valuation was actually contingent on the NSEZ's own rules and approval processes.
Wait a minute. So their own rules were being used against them in the valuation?
It's kind of a head-scratcher, right?
How does that even work?
It really makes you wonder why the valuation was so low,
Right.
especially considering that they had tried to sell the assets for a much higher price back in 2018.
Yeah.
It almost seems like the low valuation was benefiting someone else involved.
So we've got a company that hasn't paid rent in years.
Right.
A suspiciously low valuation and a powerful creditor calling the shots. This is not looking good for the NSEZ.
Yeah.
So what happened next? Did they actually get any of their money back?
Well, a company called Menace Commodities Trading came in with what's called a resolution plan, a proposal for how to handle the debt and assets of the struggling company.
Oh, okay.
And this plan was approved by the Committee of Creditors. But guess what?
What?
The NSEZ only received a measly INR 50 lakhs out of their massive admitted claim.
50 lakhs? You're kidding me. That's barely anything compared to what they were owed.
Yeah, they were not happy about it.
I bet they must have been furious.
They had some major objections to the plan, and that's where the real legal battle heats up.
Ooh, this is getting good.
We'll have to unpack all that in the next part of our deep dive.
Okay, so the NSCZ got like a seriously bad deal here, right?
Oh, yeah.
A tiny fraction of what they were actually owed. They couldn't have just accepted that, could they?
No, they did not. They raised some serious concerns about their resolution plan.
Like, what were they so worried about?
Well, first off, they claimed they were basically kept in the dark about the auction proceedings.
That's weird.
Like someone was deliberately trying to keep them out of the loop.
It does sound a little suspicious, right? Like they were being intentionally excluded.
Yeah.
So what else were they concerned about?
Well, their other big worry was that this resolution plan was basically a way to bypass the NSEZ's own rules.
What?
Specifically, they were talking about some exemptions mentioned in this one clause, Clause 10.9.
Okay.
They argued that this could lead to something they called unjust enrichment for the resolution applicant.
So the company that swooped in with the winning bid,
Right.
they were basically saying that this company was going to profit unfairly at their expense?
Exactly. And they were worried that this company was going to use loopholes in the NSEZ's own regulations to do it.
Okay, so insult to injury. It's like they weren't just losing money, they were being taken advantage of.
Exactly. And remember, we're talking about a government authority here, an entity that's used to having a certain level of control and influence.
Right.
And suddenly they found themselves in a situation where they had very little leverage.
Did they just give up and accept this, or did they try to fight back?
Oh, they fought back. They challenged the resolution plan and took their case to the National Company Law Tribunal.
Okay, the NCLT. So they went to court. What happened?
Well, unfortunately for NSEZ, they lost at the NCLT.
Oh.
But they didn't give up there. They appealed the decision and took it up to the National Company Law Appellate Tribunal.
The NCLT. So they climbed the legal ladder hoping for a different outcome?
Exactly.
Did it work? Did they find any justice at the NCLT?
No, they didn't. The NCLT upheld the NCLT's decision.
Oh, man. So 2 strikes against them.
Yeah, they were facing an uphill battle. But they still weren't done. They decided to take their case all the way to the Supreme Court of India.
Wow. The highest court in the land. This must have been a pretty big deal.
It was. And the Supreme Court's decision in this case is where things get really interesting because it starts to reveal the bigger picture of what's going on here.
Okay, I'm all ears. What did the Supreme Court decide?
Well, they ultimately sided with the NCLAT. They upheld the decisions of the lower courts. But the reasoning is crucial because it reveals a lot about how India's bankruptcy laws actually work.
Okay, so break it down for us. What were the key arguments that convinced the Supreme Court?
Well, one of the first things they addressed was the valuation. Remember, the NSEZ was arguing that the valuation of the assets was way too low.
Right.
But the Supreme Court basically said they weren't going to get involved in that unless there was clear evidence that something shady was going on.
So even though it seemed like there was something fishy going on with the valuation, the court let it stand.
Yeah.
What about the NSEZ's other concerns?
Well,
Like about being left out of the process and their rules being ignored? Did the Supreme Court address those at all?
they did, and this is where it gets really interesting. The Supreme Court pointed to a very specific and powerful part of India's Insolvency and Bankruptcy Code of 2016.
The IBC 2016?
Right. This code states that once a resolution plan is approved, any previous dues are basically wiped clean, even if those dues are owed to a government authority.
Hold on. So you're telling me that even though the NSEZ was a government entity, they were treated like any other creditor and they lost their claim because of this bankruptcy code?
Exactly.
That seems kind of crazy.
It's a key point that shows just how powerful the IBC 2016 really is.
Right.
The Supreme Court emphasized that this code was created to make the process of resolving these insolvencies as smooth as possible.
Okay.
And to make that happen, sometimes they have to prioritize the resolution itself over every single claim, even if it comes from a government authority.
So they're basically saying that speed and efficiency are more important than making sure everyone gets what they're owed.
You could see it that way. The court was basically arguing that getting bogged down in disputes and legal technicalities would defeat the whole purpose of the IBC 2016.
Right, which is to resolve these cases as quickly as possible.
Exactly.
Okay, I can see how that argument makes sense, but it still feels like the NSEZ got the short end of the stick here. Did the Supreme Court say anything about the NSEZ's concerns about their rules being bypassed?
They did. And their stance on that issue is actually just as important as their interpretation of how the IBC 2016 affects previous dues.
Okay, I'm listening.
Basically, the Supreme Court said that courts shouldn't interfere with what they called the commercial wisdom of the Committee of Creditors,
Okay.
unless there's a clear and obvious violation of the IBC 2016.
So they're basically giving the creditors a lot of power in these proceedings,
Right. They're saying that the creditors have the expertise and the experience to make these kinds of decisions.
even if it means ignoring the concerns of other parties, like the NSEZ.
Exactly. And to really emphasize that point, the Supreme Court made it very clear that the IBC 2016 overrides any other existing laws and regulations.
So in this case, the NSEZ's own rules were basically trumped by the Bankruptcy Code.
Yeah, it's like the IBC 2016 created its own separate legal reality.
And in that reality, the NSEZ didn't stand a chance.
Pretty much. The Supreme Court's decision was basically a knockout blow. It solidified everything the lower courts had already decided.
So what happened next?
Well, faced with this legal reality, the NSEZ finally accepted the INR 50 lakhs.
That tiny amount they were offered.
Yeah, it was a tiny fraction of what they were owed. But they didn't really have any other options.
So they had to cut their losses and move on.
Exactly. And the resolution plan went ahead as planned.
So this whole case really shows that even a government authority can find itself in a vulnerable position when it comes to these bankruptcy proceedings. It challenges the idea that the government always has the upper hand.
It definitely does. It's a reminder that these bankruptcy laws are complex and they don't always work the way you might expect. And it shows how powerful these laws can be, even when a government entity is involved.
We've been talking about this legal battle between the NSEZ and that company that hasn't paid rent in years, right? And this whole story, it's taken us from this special economic zone in India all the way to India's highest court.
Yeah, it's a long journey.
And it's clear that this whole thing has implications that go way beyond just this one real estate deal.
Oh, absolutely. What we're really looking at here is a clash between different priorities and different ways of thinking about the law.
Right.
On the one hand, you have this government authority trying to encourage investment and development.
Right.
But then on the other hand, you've got this bankruptcy code that's designed to wrap things up as quickly and efficiently as possible.
Right.
And sometimes that means that some people are going to lose out, even if it's a government body.
It really makes you think about who really has the power in these situations, right?
Mm-hmm.
It's like the creditors had the upper hand right from the beginning,
Yeah.
and the NSEZ was always playing catch up.
Exactly. And this case really brings up some important questions about how India's legal system handles these complicated situations.
Right.
You have to remember that India's legal system is based on common law,
Okay.
which means that they rely a lot on precedent, past rulings that kind of set the standard for how future decisions should be made.
So are you saying that this case, with its focus on the IBC 2016, could set a precedent for how other similar cases are handled in the future?
That's definitely a possibility. It could definitely influence how courts deal with cases that involve government entities and bankruptcy proceedings.
So how could this play out? I mean, some legal experts are saying that the IBC 2016 might actually be giving too much power to creditors.
Yeah, that's one of the big criticisms. You could argue that the code is so focused on resolving things quickly
Right.
that it doesn't really leave much room for debtors to fight back.
And in this case, you have the NSEZ, which is a government authority
Right.
being treated just like any other creditor.
Exactly.
It makes you wonder if this case could scare off other government entities from getting involved in similar projects.
Yeah, especially in those special economic zones.
Yeah.
If they see this case and they think, hey, we could lose millions of dollars,
Right.
they might be less likely to invest.
It's almost like a warning sign for these government authorities. Proceed with caution, because the bankruptcy code might not have your back.
Yeah, it's a risky game.
Yeah.
But there are things that these government authorities can learn from this experience.
Okay, so what can they do to protect themselves?
Well, knowledge is power, right? So understanding how the IBC 2016 works is absolutely crucial.
Okay.
These government authorities need to be a lot more strategic and proactive in these kinds of deals. They need to really think about the legal implications of their agreements
Okay.
and make sure that their interests are protected right from the start.
So it's all about being prepared and anticipating those
Yeah.
potential problems.
Exactly. It's about knowing the rules of the game.
And maybe even changing the rules if they need to.
Right.
Well, this whole conversation has been really eye-opening. We started with what seemed like a pretty simple real estate dispute.
Yeah.
And now we're talking about the complexities of India's legal system, the power dynamics of bankruptcy proceedings, and the impact that all of this can have on government entities and investors.
It's a story that shows just how interconnected everything is. The law, finance, government policy, It's all tied together.
And it's always changing.
Yeah, which is what makes it so interesting.
So for our listeners who want to dig a little deeper into all of this, where should they start? What resources or areas of research would you recommend?
I'd say start with the IBC 2016 itself.
Mm-hmm.
Get to know that code inside and out.
Okay.
And then maybe look into some other cases that involve special economic zones. And you could even research the history of common law systems.
Right, because that's the foundation of India's legal system.
Exactly. The more you understand the legal framework, the better equipped you'll be to navigate these kinds of complicated situations.
Well, this whole case has definitely made me think. And it's a good reminder that even in a world that can feel really complicated and overwhelming, knowledge is power.
I completely agree. Informed decision-making can really help people and organizations protect themselves.
That's a great point. And that's really what we try to do here on the Deep Dive. We want to give you the knowledge and the insights you need to understand and navigate a complex world.
To empower you to make better decisions.
Exactly. So thank you for joining us on this journey of legal discovery.
It's been a pleasure.
And until next time, keep exploring, keep asking questions, and keep diving deep.